Good afternoon, everybody. This is Jeff McKay from Brightsquid. Welcome to the Mandatory Breach Reporting webinar today. Thank you very much for tuning in this afternoon. We appreciate your time and attention. I'll just take a minute to introduce our speakers. So two speakers today, and we're going to go back and forth a little bit. First we have Ingrid Rice, who is sort of the leading expert in privacy compliance in Alberta. She's been involved in privacy consulting since 1987 and has been involved in programs such as POSP that got a lot of the medical clinics in Alberta set up with privacy impact assessments and targeted towards their compliance. Works very closely with the Office of Information and Privacy Commissioner in Alberta. And has consulted with thousands of clinics across the province. Rohit Joshi is the Brightsquid CEO. He has a background in law. He is a lawyer and has been studying and following compliance very closely for I'll let him answer, but over 10 years now, and has spoken throughout North America and around the world in terms of compliance and HIPAA regulations and what clinics need to do to comply. So a lot of strong background here, and I'll pass it over to Rohit and Ingrid, and they'll take us through the presentation.
Thanks, Jeff. Thanks for the introduction. I've got Ingrid with me today, which is it's very nice to have Ingrid and I in the same room. Normally, Ingrid's working out of Edmonton, and I'm mostly in Calgary. So to have us together is a pleasure for me. I don't often get the chance to present face-to-face with Ingrid. We've got a short but a punchy agenda, I'll call it, today. We've got, excuse me, we want to do a quick update with some of the history of the Health Information Act, give you examples of what breaches look like. Then we're going to take you through some of the decision making that occurs in order to determine whether or not you actually have to notify of a breach. And that's part of the change in the regulations that we're going to be talking about. Talk a little bit about what the notices look like, offenses and penalties, which are new, and then some helpful tips on how to reduce the risk of breach. So Ingrid, I'll turn it over to you for the first slide, which is a brief timeline of privacy regulation in Alberta since 2001.
Right, so 2001, obviously, Health Information Act came into being. More importantly, though, in 2011, it added 8 additional custodians, which impacted, obviously, dentists and a few of the others. It expanded the circle of care that the Privacy Commissioner sort of mandates. The MediCenters breach in 2013 was huge. It resulted in 620,000 patient health files actually went unreported. So the minister was obviously quite upset, and that in turn triggered the amendments to the HIA, which came in 2014. And it took till, well, in 2017, then on top of it all, a pharmacist was sentenced for improperly accessing patient information, and it was another trigger to actually implement the mandatory breach reporting, which will come in August 31st this year, like in 10 days.
10 days. You know, and let's start by discussing, you know, what constitutes a breach, and the Health Information Act is quite specific. First of all, there's 2 elements. First, there's a loss of or unauthorized access or disclosure of individually identifying information. That's information that would specifically identify one patient to another patient. There has to be that loss, plus there has to be risk of harm to an individual. And we'll get into some pretty specific details of how to determine whether or not there's going to be a risk of harm. And that's, you know, some art and probably some science involved in doing that. So we're going to take quite a bit of time on today's presentation to talk you through that. Finally, you know, the privacy breach occurs when there's unauthorized access or collection, use, disclosure of personal information. And that's sort of the individually identifying information that we mentioned earlier. It's unauthorized if it's in contravention of FOIP, the HIA, or HIPAA. So let's talk about the examples of a breach.
So a huge one is loss of patient information. So many times a laptop is stolen. If the OIPC gets one more call on a stolen laptop sitting in the front seat of their car, they're going to lose it. or a cell phone that contains actually patient data that some of the, physicians or dentists have downloaded onto their cell phone. Misdirected fax, patient files, etc., improper storage. A huge one is unauthorized access or unauthorized use of medical records, and snooping is huge. Human error tends to be the greatest area of unauthorized access, or lost USB sticks.
So is the snooping element is that related specifically to Netcare, Ingrid, or are people actually looking at snooping in various categories?
There is various categories, but it is admittedly true that a lot of it is once access to Netcare is opened up, oftentimes people just can't help themselves by looking at a neighbor or, it's all the information's there.
Yeah.
And then disclosure of patient information, gossiping, at a wedding dance, you can't help but talk about somebody that you saw in the clinic, or, or misdirected information, or the failure to protect it as well. And then, of course, information technology is huge. It's the cyber crime, having no backup in place, hacking, or having insufficient safeguards, having everybody with the same password, for example.
Yeah, and I think we're starting to see certainly a number of reports about ransomware that's happened in dental and some other health clinics. And it's interesting that, there's such a focus now around the electronic security of information. It's quite fantastic that we have a lot of that information electronically, but it does create a separate, almost a whole category of concern. And so we'll go through some of the discussions about that here. So let's talk about the breach notification decision tree. And Ingrid, I'm going to turn this over to you. I know that it's not easy to help make the determination of when you need to actually file a notification.
Right, so we put in this decision tree to try and help make it easier, and it's a yes or no. So if you have a loss or unauthorized access to or disclosure of any individually identifying health information, and there's a risk of harm to the patient as a result, if the answer is no, or it could be new. If the answer is no, then you do not need to notify. If it's yes, however, then you have to go to step 2 and say, okay, there was a risk of harm and there was a loss, but was that disclosure then made, let's say, to a custodian or an affiliate, or someone subject to the HIA, based on the requirements on disclosure, such as an information manager that you have a relationship with? Or was it someone who used the information to determine it was accessed in error in taking? So for example, if you are asking somebody to check your IT vendor to check in to see if there was improper access, well, if you've taken all those reasonable steps to address the risk, and it was to another custodian and you've notified them to say, oh, that was an error, then the answer is, if you can answer all those, then you say notification is not required, because let's say it was from custodian to a custodian, it stayed within the circle of care, albeit perhaps the wrong custodian, and you've taken the reasonable steps to address the error by requesting the information back or destroyed, and you've notified the correct people that the information should have gone to. You have taken reasonable steps to address the risk, you've corrected the error, and you have kept it within the circle of care.
To make it kind of more practical, let's say there's a general doctor who's sending a referral and patient information in that referral. I think what's coming up here is if it was sent to the wrong specialist.
Yes.
In that case, it is disclosure that's not really in the circle of care. But in this decision tree, the custodian who sent it to the wrong specialist would then say, okay, well, it is another custodian, even though it's not the right custodian, and therefore I don't need to report this because, in fact, it was another person who's governed by the HIA. Is that a fair way
Yes.
of looking
And
at
you've
it?
notified them to correct it and
Right.
get back the
Correct.
paperwork.
So let's go down the road of what if it wasn't one of them?
Right, so if it isn't one of them, then the question is the information secured? So if the answer is yes, so let's say it was secured information, it was an IT a loss of information through IT, and you could prove that the information was secured, let's say undistinguishable or statistical or not identifiable from a point of view that you couldn't determine this was John Smith or a specific patient. If you can say yes to that, then notification is not required. However, if the answer is no, you have to ask, what is the probability that that information was compromised, fraudulently, criminal actions, anything like that? If that answer is yes, then again, you do not need to notify because the probability was low. So it's all literally where you rank on a risk scale. If you are a low, all these are low risk, therefore notification not required. However, if it is no, then you must do the mandatory breach reporting to the minister, the privacy commissioner, and of course the affected individual.
Yeah, and I think we're going to go through some of that now. So let's say, what are the factors to determine if there is risk of harm? And here's how the legislation looks. First of all, the custodian, this is up to the judgment of the custodian, which of course is a challenge, because I can tell you in legal speak, there's a catch-all word here which is a bit concerning called reasonable basis to believe, and that's why it's highlighted, because it requires the custodian to make a judgment call. And that judgment call relates to the fact of whether or not the information has been or may be accessed by or disclosed to a person. Information has been misused or will be misused. That the information could be used for the purpose of identity theft or to commit fraud. And that finally, second to last is the information could cause embarrassment, physical, mental, or financial harm to the reputation of the individual. And finally, loss of or unauthorized access has adversely affected or will adversely affect the provision of health service to that individual. So it's honestly, it's going to be a challenge for custodians to try to determine this, because even the definition of a reasonable basis is going to be a challenge. And that's certainly where I think organizations like ours, Brightsquid, individuals like Ingrid, and legal help is going to be required in order to make sure that there's some balance in what's considered a reasonable basis to believe.
Yeah, so part of this checklist, in the case of an electronic format, if as a custodian you're able to demonstrate the information was encrypted or secured, as we pointed out in the flow chart, then in such a manner that would prevent the information from being accessed by a person who's not authorized to access it, or to render the information unintelligible, kind of like me, by a person who's not authorized to access that information. So, yeah, go ahead.
I'm just to kind of clarify again, we get so many questions about, how do we make sure, like, how do we ensure that that information is unintelligible by the person who isn't allowed to access? And from our perspective, and Ingrid, I'd love your thoughts around this. It really comes down to the quality of the IT group that you have, and really their level of certification, so that they can provide you with that assurance, and be able to demonstrate that it was encrypted. And that really requires quite a high level of knowledge. We don't endorse any specific IT firm, but we do have some that we prefer. And if you'd like to afterwards get in touch with us, we'd be happy to send you in their direction.
And then, of course, if there is a loss of information and it was recovered by the custodian, if the custodian can then demonstrate that the only people or person who accessed the information or who the information was disclosed comes back to that custodian or an affiliate, is subject to the confidentiality policies and procedures for Section 60 of the HIA, which is the slide we started with, and also access the information in a manner accordance with the person's duty as a custodian or affiliate and not for improper purposes, or did not use the information except in determining that information was accessed or disclosed. So in other words, audit logs. functionality. So basically your information managers, your custodians, and your affiliates are in that circle of care and are bound by the same act. Therefore, it has determined that the loss of information is of a lesser severity if it's within that confines.
I'm going to talk a little bit about notice provisions. So, you know, if the custodian has gone through the steps now and determined that there is risk of harm, there is absolutely a requirement to notify. And this is where things have become quite a bit more stringent. Ingrid, I remember very specifically around the Medi-Centers when that loss occurred, it was months later that that information was disclosed for 620,000 Albertans. And having been doing a lot of work in the US, I knew that this was a huge issue because this is one of the key elements of transparency.
Yeah.
For all organizations is to say, okay, this is what has happened and you are being affected or could be affected. This changes now with the new regulations. Notices must be provided via letter, electronic, posters in clinics, and those are really in the examples where you cannot get a hold of individuals for whatever reason, maybe they've moved, you must put a poster in your clinic. And the other example that I've heard quite a bit is, you know, those people without a fixed address, there must be notices that are put up. Those notices include notices to the patient, notices to the privacy commissioner, and notice to the health minister. One of the things that I recognized when we were preparing with these regulations, when we were looking at them, is the notice to the patient is quite severe. It not only includes the disclosure that a breach has occurred, but also the steps that the custodian has taken, the steps that the patient should take to further protect their information, and the ability and the full disclosure that you should, if the patient, if you feel that you would like to, you can contact the privacy commissioner and here's their address. So it's quite severe in that respect. Sorry, Ingrid, did you have
And just in regards to this, the Alberta Health has indicated that they will be providing actual notice forms or a report form so that you know all the steps that need to be taken. And as soon as that information is available, of course, we'll post it immediately and notify everyone that we have the information for you.
And so that hasn't been released yet?
We have not seen it yet, and we checked as early as this morning.
Okay, perfect.
Or as recent.
So let me just talk a little bit about the specific offenses. So the first one is failure to take reasonable steps to create and maintain administrative, technical, and physical safeguards. Those of you who've done PIAs recognize technical, physical, and administrative safeguards because those are sort of the groundwork, the bedrock of a PIA. And second is the failure to notify. And this is where, again, we've always known we needed to do the PIA, although it was never really, you know, enforceable in some ways. Now it is. The second is the failure to notify. So if there is a breach, you must notify, and that's also an offense. The penalty right now is an interesting one because Ingrid, you and I had a discussion about this. I didn't think it was going to go quite this direction. What we've seen from the US is that there's organizational penalties and then individual penalties.
Yeah.
In this case, the only thing that I can see is that there is a person found guilty is subject to a fine of up to $50,000. Ingrid, do you have any other information? Because I have not been able to find it.
Well, there's been rumors, but I have nothing documented at this point. So as soon as we hear more, absolutely we'll notify everyone as well.
Because this sort of, you know, points to the fact that this is a personal liability, likely going to the custodian, in my view, of how I would interpret it. The custodian ends up holding the bag. Although the fact that it is any person, to me, leaves the door open to maybe it's an affiliate or someone acting improperly.
Yeah, yeah.
One of the things that we learned in all of our work with the HIPAA legislation in the US was that the largest impact actually wasn't the fine. The largest impact to the clinic came from the loss of business and reputational damage to that clinic. And so that's just a reality, and I think we're going to start seeing the same thing.
Same thing here, yeah.
All right, this is Ingrid. I think you've been around long enough to help us with this one.
So I put together what I feel are the top 7 steps to reduce the risk of breach. So an assessment. privacy impact assessment, a risk assessment, an assessment on have you properly collected, used, and disclosed your information, and do you have policies and procedures, not just under PIPA, but under HIA. It'll help at least guide you in preventing or reducing your breach. Risk mitigation strategies, of course, identifying your risks. How can you minimize those risks, reduce or remove them? It's a critical thing. It is part of the PIA, but it also is good to do sometimes on your own, just as an additional step. Awareness. The current trend, so there is a preponderance, let's say in the dental community, all of a sudden that everybody's having a cyber attack. So listen to your colleagues. Oftentimes they hear of things. It's good to stay ahead of the curve. What are your most common breaches? I know in, let's say, a medical world, maybe it's faxing gone astray. And with the new breaches to faxing, you know, are you aware of this is now your biggest risk? So awareness is critical. Training, highly recommended to keep your staff and people up to date on privacy within your group. You can do lunch and learns. You can do, it doesn't need to be a 6-hour demonstration or presentation. Just stay up to date. Latest trends and what's new. IT, of course, keep your IT fellow close because they are critical. They will keep you up to date, make sure your strong passwords are in place, your auditing, your backup, and don't forget your information manager agreements. Limit information. Collect, use, and disclose only what is needed. Common sense, and that includes the disposition and storage. So make sure you're properly disposing or storing your information. And those boxes in the garage that people put in, that you know, because nobody will ever notice, that's still health information. So please be cognizant of that. And then, of course, communication. Make sure your communications, there's been a huge fax breach. They can now tap into faxes and write into your EMR or EDR. So please be very cognizant of the fact that communications also need to be secure.
Finally, I think we've got a few minutes left. Just to give you a little bit of an update on Brightsquid, of course, we do offer a complete privacy package. It's much more than a simple, not that the privacy impact assessment is simple, but it's much more than that. We make sure that you have policies and procedures, that you do have risk mitigation strategies. We also have included for all of our customers training. Those are the next training dates. If you haven't received a specific note from us, please contact us if you're an existing customer, and we will make sure that you have access. The training in Calgary is limited only because of the size of the room, and so please register if you're coming to the Calgary. The other ones, of course, are limited too, but we've got right now quite a run on the training in Calgary. We do offer privacy hotlines for all of our customers as well, and of course, added to the list now is breach reporting assistance, checklists, and a whole bunch of other things that we will be working through as we find out. We've got 3 minutes left by my clock, Jeff. If we've got any questions that have been asked that we can answer quickly, otherwise, I think what we'll try to do is answer those and publish those on the frequently asked questions on albertapia.ca. But if we have some questions, we would love to maybe tackle them in the 2 minutes we have left.
Yeah. Two quick questions. One is there any way to see the flow chart again? We'll be actually be sending that out to everybody, so that's absolutely. And we will be posting a recording of this session on albertapia.ca under the resources page, so anybody can go on there and view it anytime, because we've got a couple questions looking for that. And if you do want a copy of the slides, just reach out to us as well, and we can share those. Privacy at brightsquid.com is the best way to reach out through there. And in terms of other questions, there's a question about ransomware. Is ransomware a breach? Because I mean, we talk to clinics who get hit fairly regularly.
Yeah. So this it's a great question, and so by the strictest sense, there has been a loss of control of protected health information or individually identified information. So there's no question that in most cases that any ransomware will actually be a breach, and one that you can imagine the effect of of having to contact every single one of your patients and letting them know that the breach has occurred. In fact, though, if that information was encrypted and you can prove that it was encrypted, it looks like the Act actually will actually allow you a bit of a pass. Because if you can prove that it was encrypted, going back to one of those criteria, it's unintelligible to the recipient. So it won't help you get your information back. That's a whole other discussion. But what it will do is prevent you from having to notify every single one of your patients that you've lost their data. Is that clear enough? Ingrid, is that your interpretation as well?
Well, yeah, and the word lost your data is maybe not exactly right, because the data won't be lost if it's unintelligible.
Right.
So you still have, the data, or you may be able to restore from your backup. The bottom line is it is not as reportable as we once thought.
Yeah.
If you can prove it was protected.
And that's where you get having very good sort of documented processes, having a very good IT firm which is documenting their processes and verifying and so on. That's going to be critical.
I'll just quickly, because we have maybe not any time left, but can we address quickly who is a custodian?
Yeah, so you've got chiropractors, pharmacists, dentists, RNs, registered nurses, denturists, midwives, opticians, of course, physicians and surgeons, podiatric physicians, dental hygienists, and optometrists are currently on the list, as well as, of course, Alberta Health Services, Covenant Health, et cetera, et cetera.
Perfect.
But those are the primary custodians from a individual point of view.
Great. Thank you. Well, that brings us to our time today. Any other questions, as Rowan mentioned, we'll post on our FAQ. And as I've mentioned, we will post a recording of this as well on albertapia.ca under resources, and we'll make available the flow chart for the decision tree there. So thank you again very much for your time today. If you have any questions about privacy compliance, about breach avoidance or breach reporting, certainly please get in touch. Any other comments?
Thanks, everyone. No, thanks.
Thank you.
Perfect. Thanks so much.